All right. Now is the time set, if everyone's ready. Now is the time set for oral argument in cause number 1 CACV 140786, and I will pronounce it as Quam versus Grove. Counsel, is that correct? Thank you. For your information, these proceedings are being both audio and video recorded, so barring any problems with the system, you can critique yourself on YouTube in a couple of weeks. Counsel, each side will, as I know you understand, be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know, and we will try our best to take up.
Mr. Jones is the appellant, so we're sitting on the wrong side.
Oh, you guys are on the wrong sides?
We can switch.
You know what? We may be able to deal with that. It's okay. Then if you wish to reserve some time, please let us know, but ultimately the keeping of that time for rebuttal is up to you. We have reviewed the briefs and conferenced the case this morning. We are well aware of the facts and issues attendant to the argument. You might want to keep that in mind in addressing the court this morning. Please stay with the meat of your issues, and we do want to hear what you have to say. Counsel, when you come to the podium, I would ask that you state your name and who you represent, and with that, you can begin.
I think I'd like to reserve 3 minutes. Yeah. I represent the appellant, Kathy Quam. She filed to replace the original personal representative, Teresa Grove, because Teresa Grove was divorced from Robert Grove, and that voided out all the provisions by law of her priority for personal representative, and it voided out her priority for appointment. And also note that she never notified Kathy Quam or her sister of the opening of the estate. And a trial to remove her, we believe the court made 2 errors. First of all, the court allowed a prohibited testimony under ARS-122251, and that substantially affected the court, although they did not find fraud on behalf of Robert Grove. They did find that based on her testimony, and basically her testimony alone, that the parties had extensive negotiations and knowledge of the property settlement, and that they incorporated that into their divorce decree. Now, when you look at the divorce decree, it, however, holds 2 mutually contradictory things. The divorce decree, at one point, and the main body of it, says the party waive all right and marital interest in the other's retirement, deferred compensation, and pension accounts. Then in the attached document, it has a rather extensive division of the property, both of which were signed on the same day, and both of which were approved by the court. But that leads to two opposite conclusions in the same divorce decree. The court, based on Teresa Grove's testimony, determined that the Exhibit A was the controlling exhibit, and that they said he looked at he decided to take the decree as a whole. And again, we can't see that these 2 mutually contradictory clauses that negate each other. And so I don't see how I interpret it as a whole, but he did rely on her testimony to go ahead and say that it was clear that the parties were trying to arrange for the pensions and disposition of life insurance. But that's not clear if you remove the inadmissible testimony, then it's not clear. They just negate each other. And then within 2 weeks. Now, normally, I think if they had time, Teresa could have maybe filed to have the court order him to comply with the terms of Exhibit A. Either one rule, one way or the other, as to which was controlling, which it didn't do. And then, second of all, to apply that, or to order him to go ahead and redesignate Teresa Grove as beneficiary of the life insurance, or both life insurance policies, and as the state retirement. Neither of which he did. He died 2 weeks after the divorce decree was signed, and so that really wasn't time to force him to comply. And the second item that we're talking about is that the court had no jurisdiction over the insurance. It awarded the smaller life insurance policy, which was the only one that was focused, or it was the only one that was in existence, ordered 100% of that to Teresa Grove. But again, Teresa Grove, by operation of law, was dropped as a beneficiary.
So how is it that jurisdiction does not exist in the Superior Court?
Jurisdiction over what?
You said they didn't have jurisdiction.
Oh, yes, it says that.
I want to be real clear on how the Superior Court does not have jurisdiction of these issues.
Okay. In State of Jones v. Salas, 4160 P. 2nd 16, 10 Arizona App 480, the court held that, moreover, a probate court has only jurisdiction over the property of the estate of the deceased. Where the estate of the decedent is not designated beneficiary, the proceeds of a life insurance policy do not become part of the estate of the insured. And a beneficiary on an insurance policy takes by virtue of a contract of insurance rather than the laws of succession. So our argument is that once she was dropped as a beneficiary, the provisions of that life insurance policy were basically blank. Ultimately, it might have gone. Ultimately, it probably would go to the estate, but it was not property of the estate at the time of Mr. Grove's death.
Okay, thank you.
So basically, our argument is the court allowed inadmissible testimony, even though it found there was no fraud. They did take into account, the minute reflects considerable reflection on the testimony given to it, that Robert Groves negotiated the terms of the divorce and negotiated the retirement fund. I think it's more likely he did neither. He was in a debilitated condition, and he just neglected to do anything. And that's why we say that you can't really, again, according to the probate code, you have to go on the written word of the decedent. And in this case, the judge relied on the testimony from Teresa Grove that they had extensive negotiations and that they intensively had an agreement regarding the disposition of the property. Also, he made a conclusion that Teresa and Robert Grove made determinations over whether or not how one was to procure housing. Robert Grove was especially vulnerable, but even Teresa Grove, they wanted insurance policy to cover their if they died, the other party would be given the funds in order to have housing. Again, that's not in the record anywhere except for the testimony of Teresa Grove, and therefore and that was inadmissible because that was basically testifying to his state of mind. And We therefore would like that should be stricken, and if necessary, retrial with that testimony omitted, so that another judge could determine whether or not he had any intention whatsoever, because I don't believe that he really had any intention, one way or the other. So that basically is our argument, that Teresa Groves, again, knew or should have known that she was eligible to apply for personal representative, and she applied and actually began collecting assets of the estate and putting them in her own name. And that's when we filed to remove her. So thank you.
Counsel.
Good morning, Your Honors. Richard Faber on behalf of Law Offices of Mark Hall. I would like to first say our challenge was great here in that if you have read the briefs, the first two were stricken for not complying with rules. The court allowed him to file a third opening brief, which changed all of 2 sentences. Even in spite of a second motion to dismiss. What Mr. Jones just said, I'd like to approach with the court's permission to try to present what is virtually incomprehensible in his briefs and in his reply as to the issues that are before the court in an organized way with 3 steps that will require, first, an interpretation of the consent decree, and with the application of 2 statutes to that consent decree, this court will conclude that what the trial court did was precisely correct. The parties entered a consent decree 2 weeks before the decedent died. The consent decree consisted of an initial, what I'll just call format decree, together with an Exhibit A. Exhibit A set forth with specificity all of the breakdown of all of the assets of the estate. Mr. Jones's initial claim below was that because the first part of the decree stated that each party waives and gives up any right or marital interest in the other's retirement, deferred compensation, or pension accounts, that Exhibit A, which specifically dealt with all of those and broke down 401k, IRA, life insurance, and ASRS, Arizona State Retirement System, divisions, was somehow not applicable, in that the first boilerplate provision overruled the specific provisions contained in Exhibit A, which went so far, it's Exhibit 6 to the trial court record. Exhibit 6 went so far as to not only do all of that, cars, houses, bank accounts, and all of the retirement issues, right down to a sheet of dishes, towels, dishwashers, etc. The trial court indicated precisely on the record, as we noted in our responsive brief, that it was not relying on any parole evidence. It said, I believe the documents, i.e. the consent decree, do what they say they do, and disregarded parole evidence, i.e. Teresa Groves' testimony. He also, as we indicated in our answering brief, the purpose of calling Ms. Groves was to establish that as part of the dissent decree, each had agreed to keep each other as beneficiaries on their life insurance policies as part of Exhibit A, which A granted Mr. Jones' client the house, but with the stipulation in Exhibit A that both parties keep each other on their life insurance policies as beneficiaries for a period of 4 years in order to give him time to refinance the home. After Mr. Grove passed away, it was discovered, they believed it, both of them, that those policies were relatively equal. Hers through USA Airways, his through Arizona State. It was discovered that he had not paid the premiums. Despite multiple notices, while the negotiations were going on, he had not paid the premiums on the larger of the policies, over $130,000, leaving Ms. Grove in the position that when her husband passed away, she was only entitled to $70,000 instead of $250,000. We put Ms. Grove on the stand for the purpose of trying to establish that Mr. Grove's failure to pay the premiums resulted in Ms. Grove being defrauded, and that rather than just get 50-50 of the ASRS funds provided for in Exhibit A, she should be entitled to more than that to make up for the difference. That's why Ms. Grove was called.
And you lost on that.
We lost.
Right.
But having said that, from what Mr. Jones just said, the court specifically said with respect to the consent decree, it was not relying on Ms. Grove's testimony. It said, the court said, I am not relying on any parole evidence because the documents do what they seem to say. Now, how did he reconcile Exhibit A, which specifically set forth all of the deferred retirement, IRA, 401ks, and the life insurance, which was linked to giving Mr. Grove the house? In other words, he got the house so long as the life insurance remained in place. How did he reconcile those two apparently conflicting terms? Here's what the court said, and he went back to first semester of law school to do it, and it turns out he was right. He said, I am going to interpret the agreement as a whole, and he also said, and I think the specific takes precedence over the general. Those are two contract interpretation principles that, again, go back to first semester of law school. If you have a document that appears to have conflicting terms, in this case, that's exactly what we had. We had a general provision that said they share nothing of their retirement, pension, life insurance, and then we had an exhibit that specifically broke it down item by item by item by item by item as to those items. So Commissioner Reese's evaluation of the enforceability of the consent decree, in our view, was absolutely correct. He applied the law correctly. Secondly, even more ironic is that they would challenge the validity of Exhibit A and the breakdown when, after Commissioner Reese issued his order, part of his Exhibit A was that they got the house. Part of Exhibit A was that as to this breakdown of personal items, they would be split according to what was put forth in Exhibit A. So what did they demand of Commissioner Reese, which he did? That pursuant to Exhibit A, they be ordered title to the house, my client be ordered to vacate it within 7 days, and they had an appraiser come in within 2 days to appraise on this list of who got what on Exhibit A of what it was worth. Now, what ultimately happened is, before the 7 days was up, they finally realized the house was underwater, as we've been trying to persuade them, and their appraiser decided that all of the items in Exhibit A due to Mr. Jones's client were essentially worthless. So Ms. Quam took back off to Minnesota. They quit-claimed the deed back to my client for the house. Now, she didn't have to do that. Legal advice would have been, hey, the judge ordered pursuant to Exhibit A, which he incorporated by reference into this document, you don't have to take it. But of course she did. She was here. It was her credit on the line. She was the one involved in the short sale, working with the realtors. The newly appointed personal representative was doing nothing. So she accepted that. All of the point being is that Exhibit A and its terms regarding the distribution of life insurance proceeds and ASRS funds is one complete document. Now, Mr. Jones, at least at this point, unlike his opening brief, which he stuck with even after we challenged him on it, he kept saying that the court awarded Teresa Grove 1/2 the life insurance policy. We pointed out in our answering brief, no, the court didn't. What the court did on page 6 of its order, it couldn't have been clearer, said, quote, in that regard, the court orders that Teresa Grove keep the insurance proceeds. The IRA goes to the estate 100%, by the way, pursuant to Exhibit A. And the ASRS retirement is to be split 50-50. Again, exactly pursuant to Exhibit A. Having established, I believe, that Commissioner Reese's interpretation of the consent agreement was correct, that despite that apparent conflict, they abided by the terms of Exhibit A, they demanded that the terms of Exhibit A be enforced, the IRA money in Exhibit A was transferred to them following the hearing. They ordered her, as part of the order, to vacate the home as part of Exhibit A. It's been established as one document. Their next point was, so that takes care of Teresa's oral testimony, which was the first issue. The next point they raised was, no, still no good, because the law requires, under 2 statutes, they didn't say the statutes, so I'm going to tell them to you now. The law requires that because Ms. Grove did not Mr. Grove, after the decree was entered, even accepting Exhibit A governed, he did not redesignate with ASU Life Insurance. Ms. Grove is the beneficiary, and he did not redesignate with the Arizona State Retirement System with her as the beneficiary. I'm going to start with the retirement system because that's the easiest. There's a specific statute that governs beneficiaries of Arizona State Retirement System funds. And that statute, which we cite in our brief and cited below, is ARS Section 38773D. And what that statute says,
Counselor, what is the statute now?
it's 38-773D.
Sure.
Now, and we brought this up, and that's finally when they stopped. If you look at the transcript arguing this particular point, that she had a duty to he had a duty to redesignate her as beneficiary of her 50% of the ASRS funds. Here's what that statute says. Except as provided by the express terms of a domestic relations order, the divorce or annulment of a marriage revokes any revocable disposition or appointment of ASRS benefits to a member's spouse, except as provided by the express terms of a domestic relations order, which we have here. So there was no need whatsoever to redesignate. That one's simple. Where it gets a little bit more complicated and a little bit more interesting for this court, I think we'll find interesting, is that Mr. Jones continued to assert that Mr. Grove was required under ARS 2804 to redesignate Ms. Grove because...
Give me that ARS provision again.
Yes, ARS 14-2804.
Thank you.
That's the overall statute that says when there's a divorce, things go away. Personal appointments go away, beneficiary designations go away. It's an overall statute. It's called an automatic revocation statute. It's based on the UPC 804. And there are about 15 states or so now, give or take, that have adopted this. But there are two exceptions here that are important. What that statute says is, except as provided by the express terms of a governing instrument, a court order, or a contract relating to the division of the marital estate made between a divorced couple before or after the marriage, divorce, or annulment, the divorce or annulment of a marriage revokes any revocable disposition or appointment of property made by a divorced person. Here's the key. It says, except as provided by the express terms of a governing instrument, a court order, or a contract. Here's how the cases in Arizona have interpreted that. First, court order means what it says. The express terms of a court order here awarded or mandated that Mr. Grove keep Ms. Grove as a beneficiary of his life insurance policies for a period of 4 years. Court order mandated that he keep her as a beneficiary, not that he redesignate her. Counsel says in a brief, in his reply brief, Mr. Grove agreed to redesignate. No, he didn't. Mr. Grove, in the consent decree, agreed, they both did, to keep each other.
Counsel,
More-
we have to reach the statutory issues. As I read the appellant's opening brief, it seems to be saying, and as I understood his oral argument, that the only issue is whether the probate court had jurisdiction to do what it did. And we don't need to go into the statutory.
All I'm saying is he says more. And in his reply brief for the first time, although it ties in a little bit with what he said below, he hammered and hammered and hammered and hammered and hammered on the redesignation issue.
Okay.
And he cited authority, an Arizona case, in his reply brief for the first time that says you need to redesignate.
Okay.
My point in exploring this is you don't, and the case he cited and the case that comes from that and the cases cited within that, just note the case he cited in his reply brief.
Sure.
It is true that you do, as a general matter, have to redesignate. It's automatically revoked unless there's a court order or a contract. And what the courts have said is the separation agreement is a contract entered before the marriage, and the court order is. So you don't have to revoke.
But technically, I understand your argument.
Well,
Just say-
it's become a more interesting argument to me because after I got that case, I did even more and more research, and there are thousands of pages that have analyzed that issue. What this court has never said, what it's said by inference, is that a separation agreement is a contract that takes it out of the automatic revocation, and that a divorce decree is a court order that takes it out of the automatic revocation. That's all by inference. This court has never said outright affirmatively a court order that's a divorce decree takes it out of the automatic revocation.
But if he didn't raise it in his opening brief.
This was in the reply brief, which raised new issues, and it raised that issue.
Okay.
So,
I understand why you don't want to just say, oh, he waived it. And I understand.
well, and it was important to him on the redesignation.
Let me.
On jurisdiction, he made a point in his reply brief for the first time that was surprising and hard to figure out, as was most of his briefs, because as I pointed out in my motions to dismiss, 80% of his briefs didn't cite to the record, so it made it very challenging. But he says for the first time in his reply brief, the family court, because what the probate court had said, as Mr. Jones asked him when he was going to enforce the terms of the consent decree, exactly as written in the consent decree, Mr. Jones asked him, he said, is this court going to make a domestic relations order? And Commissioner Reese said, yes, we are a unified court under the Constitution. I can do it, and I'm going to do it.
Okay.
That solved that problem, But in his reply brief for the first time, he said even the family court of which where the consent decree came from, that Commissioner Reeves was then enforcing in the probate court and interpreting, did not have jurisdiction because a life insurance policy is outside of, which generally, again, it's a non-probate transfer.
Right.
Here why, it's the first time he brought it up in the reply brief, that said the family court didn't have any jurisdiction. He didn't even tell Commissioner Reese that. He just said that. Here's the difference. The way this consent decree reads didn't just give life insurance money to my client. The consent decree was unique in that the life insurance money was tied to the disposition of the home to the husband on the condition that he keep her as a beneficiary of the life insurance policy for up to a period of 4 years. So you've got an interaction. It's not just as if the court said, I am awarding Ms. Grove $1 million in life insurance money. That he would be right on jurisdiction. That's not what was going on here. There was an interaction of the standing as a beneficiary of a life insurance policy that ran with, where he wouldn't suggest there was no jurisdiction, to order the award of a probate asset, which was the house.
Counsel, we need you to wrap up here if you can.
So that is all I have to say. I had, because of many issues he touched on in his briefs that he didn't in his oral argument, I had more to say. But
Thank you.
Thank you.
Counsel?
Okay. I really only have one point left, which is an issue for this court, which is the decree of divorce was clearly defective. It got past the judge, and they contained two contradictory statements. And again, for Commissioner Reeves to interpret it as a whole justifies common sense. And he did not say in his minute entry that the interpretation counsel put on it, which is to say that this is a more extensive argument and more detailed, and therefore it controls. It doesn't say that. It says they're both equally, well, actually, the main decree, I think, is more valid. But at least you say they're both equally valid, and they both have contradictory provisions in them, which would tend to void them out. And I think had Mr. Grove lived long enough, the parties would have had to relitigate. But he did not, and that's where basically his death was an intervening factor. And that means that all of his intent to dispose of the property were voided out, and his intentions as manifested at the trial, which frankly Commissioner Reeves said he would not take into account parallel evidence, but frankly after half an hour's testimony and his citing of the testimony clearly revealed that he did take into account the parallel evidence or the testimony of Teresa Grove, because he cited her several places about how Mr. Grove, he basically got in the mind of Mr. Grove and said this is what he was thinking of at the time that he signed it. So I think it's fatally defective for that reason.
Thank you, counsel. All right, we appreciate your oral argument. It is concluded at this time. We are going to take this matter under advisement. We will rule in due course. Counsel, thank you very much.
Thank you.
You okay? And we're going to go ahead and stay here and start the third case. So if we can exchange places, we'd appreciate it.